people, when you talk to gun control people, remind them there was no such thing as a federal background check until the 90s because people seem to think it's the be all and end all of keeping us safe. Funny, really hasn't been around that long.
Yeah, it's kind of like an income tax.
Yeah, which is illegal.
Get out of here with that. We are the Armed Attorneys. Today we're talking about an awesome new lawsuit that is coming from the Firearms Policy Coalition that seeks to strike down the interstate transfer rule when it comes to federal firearms license dealers. This thing is a humongous headache, doesn't make any sense, but let's talk about the lawsuit, where we think it's going to go. But before we begin, show your support for the Second Amendment by hitting that like button. And I'll just start off by reading this caption if y'all want to start following this case along, and we'll throw it up on screen. This is Elite Precision Customs, Tim Herron, Freddie Blish, Firearms Policy Coalition versus ATF. This is case number 425CV00044-P. And so what are they looking at dismantling?
Well, we have the Gun Control Act of 1968.
Hate that guy.
I hate that guy. Passed in the wake of, some assassinations. So that's the best way to get Congress to pass really sweeping gun control is, particularly politicians getting shot. That'll get you some gun control. So before 1968, and of course the GCA has lots and lots of things to it, but we're talking about one specific provision here, which is the interstate transfer laws. And prior to 1968, it didn't matter where you bought a gun.
Sears catalog.
Sears, someone commented that on our video we did a couple days ago.
Yeah.
Get you one from the Sears catalog. And in 1968, we said, whoa, 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 whoa. In fact, I do think it was a mail order gun that killed, was it MLK? It was one of them. It was one of those assassinations.
They just declassified it. I haven't gotten to that yet.
Oh, I'm pumped. There are a couple of conspiracies I'm here for, and the CIA killed Kennedy, and Justin Trudeau is Castro's son, are my top two.
There we go.
So back to the topic at hand. So this was a big deal. We have put this 18 USC 922B3 into place, and we're just going to flash up on screen, and we'll read in relevant portion. And this has been the law since 1968 on purchasing firearms interstate.
All right, it says, and I'm going to jump over a couple things, but it says it shall be unlawful for any licensed importer, licensed manufacturer, licensed dealer, or licensed collector to sell or deliver to any firearm to any person who the licensee knows has reasonable cause to believe does not reside in the state in which the licensee's place of business is located, except that this paragraph shall not apply to the sale or delivery of any rifle or shotgun to a resident of a state other than the state in which the licensed place of business is located, if the transferee meets in person with the transfer to accomplish the transfer. And there's there's some more language there. There's some exceptions and things,
yeah.
And we could talk about it, but that's the gist of it.
Right. So
what does that mean in plain English?
Plain English. So if you are an FFL, you cannot sell to someone out of state. And in fact, this applies to, private sellers as well. There's penalties on the buying side as well for buying out of state.
Yeah, that lives in 18 USC 922A3.
So we've got the law all the way around punishing everyone. There are exceptions, as Richard has said. One of them he read out, which was you're buying a long gun out of state in person, at the FFL dealer. For the places that will actually engage in that exception, they have the discretion to engage or not engage in that. Another exception is a temporary loan of a firearm for sporting purposes. So imagine
not self-defense.
No, not self-defense. But imagine you go to a gun range in a state you don't live in, you rent a gun. That's fine.
Yeah,
right?
Or let's say you're visiting family member going on a hunting trip, they loan you a firearm for the hunt.
Great, yes, fine. And that's not, these aren't permanent transfers, so they're generally going to be exempted from that transfer law anyway. And then we've got other exceptions that aren't as relevant here, like receiving firearms interstate because it's part of a will, but anyway, we don't even need to touch that. But so we've got this, we're talking about being able to buy a gun out of state.
Yeah, or in this law specifically, purchase a handgun from a FFL gun store in another state.
Right. Which happens. I have people call me all the time. They're like, I am visiting my family member in Indiana and I'm at the gun store and I see this handgun that I absolutely have got to have. It's a great price. I love it. What can I do? And the answer is
jump through a bunch of hoops.
That's
terrible. And that sounds like
hoops, pay more money.
Yeah. Hoops sounds like an infringement.
Well, well, hoops and infringement. But yeah, I mean, generally it's like, that's the one you want. And if it's one of a kind, it's like, okay, hoops, I'll go through my hoops. But a lot of times it's like, this is the price. And it's like, okay, great. Well, so what you're going to have to do is you're going to have to completely destroy any discounted price that you were going to get because you're going to have to ship it to an FFL dealer in your home state. And they're probably going to charge you fees on both ends. And you're going to, I mean, it's gone.
Yeah, so this is terrible. And so this case is in the Northern District of Texas. And we have a case, this is back from 2015. This is Mance v. Holder. It's 74 Federal Supplement 3rd, 795, if you wanted to check it out. And so we actually have the Fifth Circuit Court of Appeals upholding this specific provision of law just a few years ago. But 2015, that's an important date because something important hadn't happened yet.
Yes, so 2015 is, of course, 7 years prior to New York State Pistol and Rifle Association versus Bruen. So, what the appellate court did in Mance was apply strict scrutiny, which I'll give them that. They didn't apply intermediate scrutiny.
Yeah.
But this was specifically a Second Amendment challenge. It violates my Second Amendment rights for you to deny me an interstate purchase. Great. Love those challenges. Those challenges were worth as much as the paper they were written on prior to our Bruen case, because courts either didn't apply strict scrutiny, or even when they did, they said, well, the government can pass strict scrutiny muster by narrowly tailoring the law to serve a compelling government interest, such as the public safety. So that's what they said here.
Yeah, so in that case, the government is saying, hey, guess what? This is only non-residents. This is only handguns. They agreed with the government in saying this thing is narrowly tailored. They upheld this law as being constitutional. But, all right, we got New York State Rifle and Pistol Association v. Bruen. We now know how we judge Second Amendment infringements. It's not going to be a two-tiered test like intermediate or strict scrutiny. And so, essentially what Firearms Policy Coalition is saying, try again, buckos, because, you applied the wrong test. And I will say that Mance case is still going to be helpful because they kind of did part of the court's job already.
In a bizarre twist of fate, they did a robust historical analysis, which they were under no obligation to do at the time, of firearm laws. And they actually, the court concluded that there was no restriction on the interstate purchase of firearms, none, until 1909 is the first thing they can come up with.
Yeah, and so when we look at our New York State Rifle and Pistol Association v. Bruen test, we look, hey, Second Amendment implicated. If yes, laws presumptively unconstitutional. Burden on government to show based on the text of the Second Amendment as informed by history and tradition. This is some type of regulation that would have been around at the time of the adoption of the Second Amendment, 1791. 1909, that sounds like a long time away.
It does. And I think what is interesting here, although unnecessary, but interesting, is that FPC and plaintiffs are adopting this line of reasoning, which I think was mentioned in the Mance case as well, though now my memory could be a little fuzzy on it, that it really, in 1968, there was no such thing as a NICS check. People, when you talk to gun control people, remind them there was no such thing as a federal background check until the 90s, because people seem to think it's the be-all and end-all of keeping us safe. Funny, really hasn't been around that long.
Yeah, it's kind of like the income tax.
Yeah, which is illegal.
Get out of here with that.
So anyway, we've got a NICS background check, which I know a lot of you are saying, that's unconstitutional too. That's a case for another day.
Yep.
But basically their argument here is, look, even if you are going to consider in the back of your mind the public safety, there's no public safety threat, because in 1968, no such thing. We don't need to worry about the confines of state boundaries to keep people safe. If a background check does the job, it's the same background check everywhere in terms of the federal government. So here you go.
Yeah, part of this restriction, I guess, and I don't know if this is going to be part of this challenge or not, what I guess is maybe a trap that FFLs, you got to be careful. Let's say this law does get struck down. Theoretically, the law currently requires that the firearm be legal in the state of the person. Whoever the purchaser is, wherever their home state is, that the firearm has to be legal in that state. I don't know that that's going to be addressed in this case.
I don't know that that's going to be. I mean, can we just like
I'm not gonna doom for. I'm not gonna doom.
no, well, yeah, let's not do their jobs for them. But also, like, can we for a moment just impose like just a modicum of personal responsibility on people and say, if you go out of state and you buy something that's illegal to take back to your home state,
That's on you, Bucko.
burden's on you, buddy. You get caught with it, that's a crime. You will be, rightly or wrongly, you will be held responsible for that. I mean, why is it the federal government's responsibility to nanny things like that are really only going to affect the person who made the mistake?
No, I completely agree with you. Now I think is the time of the segment where we go crystal balling and say what's going to happen
Ooh, I
to
love
this.
crystal balling.
What happens to this case? I'm very, very hopeful.
I am very, very hopeful. The fact that the historical analysis is done is very promising. It's hard now because, I mean, the government is the government, right? Whether it's the ATF now or Eric Holder in 2015, the government comes back in with a brand new set of smackdown laws. Like, no,
No, they
I
don't.
mean,
They don't have a time machine.
no, you don't have a time machine. You did your research with competent counsel back in the day, and anything you come up with now, it's like, well, why wasn't that important to you in 2015? Now, that doesn't necessarily mean that if they found, that 1776 law that no one knew about that said that you can't sell firearms between the colonies and we're going to put you in prison if you do. It doesn't
Sure.
exist. But if they found it, sure, we got problems. They're not going to find it.
Well, and folks be skeptical when you see new examples of historical gun laws. And I'm just going to point at the Duke Law Center because what they will say is, they'll say, oh, look at this law that prohibits interstate transfer of firearms. This was around in 1776 or whatever. And then if you really follow it down the rabbit hole and like follow the links that they provide, it's like this law has nothing to do with that. And
Nothing.
so if you read it on its face, okay, Duke Firearm Center, I guess we got to take them at face value. But when you go and actually look at the historical statute, you'll see like it has nothing to do with what they claim it does.
Right. So, I mean, it is. I am confident. Plus, of course, we've got the Northern District of Texas, which is wonderful. We've got the Fifth Circuit, which is great. Um, you know, cross your fingies for the Supreme Court. They've
Yeah.
done some weird firearm stuff recently, but just cross them.
Yeah, but I'm hopeful. We hope you enjoyed this discussion. If you did, consider subscribing, hit that like button, and help us fight the anti-2A algorithm by sharing this video.
And please question and comment below. Let us know what you think. Is this the case that brings down the Gun Control Act? Until next time, we're the Arms Attorneys.